Thank you. Please be seated. All right. We'll now hear the argument in case number 22-30221, Robert versus Maurice, and we'll hear from Ms. Motta.
Good morning, Your Honors. May it please the Court. My name is Vanessa Motta, and I'm here on behalf of Plaintiff Appellant Reginald Robert. Defendants in this case filed an affirmative defense. Plaintiffs intentionally caused the accident. Intent is a state of mind, mens rea. However, defendant's intent in this case was not just that. This was the back door to make sure that every type of allegation, prejudicial attacks were put into this case. The district court failed to be the gatekeeper of this. This has been a wave of what defendants have been doing for quite some time. There has to be some guidance, which is why we come here, to not only reverse, but to remand with instructions as to how to set the tone, because this has been happening for quite some years in the Eastern District. I will hit 5 points into this case as to the district court had erred.
Yeah, I'd like to get pretty quick to the verdict form that the jury signed. They found against your client because they found that the injuries were not caused by the accident.
Yes, Judge Davis.
So then the judge entered a judgment on the verdict, and why isn't that the end of it?
I'm sorry, what was the last
Why
point?
isn't that the end of it?
Okay. Well, that's a great question, Your Honor, and it's not the end of it because it's clear from the testimony that was given, there was no medical causation that was disputed by the defendants. There was motion for summary judgment that was filed prior, and when there is any type of allegation of pre-existing injuries, the only way to satisfy that burden is through expert testimony. Because of the...
No, you can call into credibility the witnesses the plaintiff calls.
Well, Your Honor, there was so much attack on my client that he did not have a fair shot. It's kind of as if the jury knew that the client was not at fault with the collision because there was a video. I mean, it was clear as day. However...
I'm talking about the credibility of the doctors. In other words, when I think both doctors testified that when he came in for examination, he denied having any prior accidents. And so the defendant put in the 3 other suits that he had filed where he alleged that he hurt his neck and his back. So why wasn't the jury entitled to consider that the doctor didn't have correct history to base a causation finding on?
Actually, I think you're a little bit incorrect, with all due respect, Judge Davis, that he said that he had treated for chiro prior. In fact, the intake forms in the medical records show...
Yeah, but the chiropractor testified that when he came into the office, he told him no prior accidents.
So the question in the medical record said, have you treated for chiro before? And he said yes.
What about your pain doctor, your main doctor?
Dr. Lonseth. Yes, in his records, it also states that. So
yeah, but he told the doctor when he came in, I've had no prior accidents. That's the history he gave the doctor.
So with as far as the credibility on that, even if that were the case and so, we still go the factor of that was over 3 years ago, and there was no evidence to show that my client had done any treatment. And that is the point.
Yeah, but in his testimony, your client kept saying he'd never had any injuries, even though he had sued for injuries. I mean, so not believing him wasn't hard for the jury. His testimony was unbelievable how much he was... We're just reading a transcript, but I could hear him. He was constantly saying stuff that he had to back out on. He kept fighting that he didn't have injuries, and the defendant's lawyer kept showing him that he'd sued for injuries. Oh, I only had pain, I didn't have an injury. I mean, so he's obviously someone who says what he thinks he needs to say in whatever context he's in. Well, that's not very believable, is it?
Well, And I can understand that, Your Honor. Again, with the transcript, I know it's hard to get the emotion. From what he was trying to explain to the jury is that this is talking about a pain management. And he was trying to explain that he had never been to a pain management. So he had been to Cairo, he had soft tissue. He did explain that in his intake form. But then it got to the different standard of now we're dealing with pain management. So even if we were to go into the concept of I had a prior Cairo, he had never been in that status of getting injections, rhizotomies. I mean, this was becoming now a different level. And so he was trying to explain that. And granted, I will agree with you, it probably wasn't as clear as what it should have been, but that's what he was trying to explain to the jury, that that's what he's never done before. Having soft tissue pain is not the same of having a herniated disc pain that was depriving him from working in the field that he was normally doing.
When you read that record, it didn't come across that way.
Completely understand.
The jury was entitled to accept that he didn't testify that way.
Completely understandable, Your Honor. And again, I know words don't have the full context of emotion of everything of the explanation, but clearly that is what my client.
Yes, but that's what the jury determined. So as I said, I kind of felt like I was hearing the transcript. I mean, I was a trial judge for many years, so I'm familiar with that. But it doesn't matter what I think. A jury could certainly watch him saying all this stuff that was inconsistent at best and a lie at worst and conclude that it is a lie.
And that's
And so it wouldn't be that hard for them to believe that he wasn't fully truthful with his doctors. And that's why the doctor's testimony doesn't have to be believed. That's different from a summary judgment. Putting the doctor's evidence stops the summary judgment, but it doesn't mean the jury has to accept what the doctors say unless the defendant comes forward with a doctor who says something else.
Which in this case, that didn't happen. There was no IM.
I understand that, but the jury doesn't have to believe the doctor. The judge can't say, well, I don't believe the doctor on a summary judgment, but the jury can do that. Or they can say, well, maybe the doctor's doing the best that they could, but they weren't fully talked to by this guy we just heard, or that we heard during this trial, and who wasn't very truthful.
Yes, Your Honor, and I think that goes into the connection of when it talks about credibility, they go into the other factors as to what else was presented in this case. Since there was such a credibility discussion in regards to that specific testimony, the jurors looked at the other credibility factors, and that's where I believe this is what comes into hand in hand as to why things that had to do with the non-party, the reading of an indictment that had no connection to my client, a criminal defense attorney of that non-party coming in to testify.
Counsel, I know you're saying all of that should have been kept out of the case, but what I'm trying to understand is this. Was liability a question in the case? There was a question in the case about who caused the accident. Is that right?
That is.
And that was an issue for the jury to decide. Who caused the accident?
Right.
And so if there's information that the accident was deliberately caused by the plaintiff, how is it appropriate that a judge could exclude that information from the trial where you're trying to determine who was at fault in causing the accident? How do you keep that information out? Because that's what you wanted the judge to keep out, right?
Yes, Your Honor, great question. So there has to be a link. And so if we go first and foremost into the indictment, we have a case of the U.S. versus Beecham, and in fact, I'll use your case, it was U.S. versus Ebron, that really was set the tone as to the two-part test that we have to do. But furthermore, in your case in Ebron, it actually used that the judge had to do a contemporaneously instruction to the jury onto what to include as for the limited purposes of it, and that didn't happen here. First, when
you asked for an instruction and the judge refused it?
No, I did not ask for it. I asked to exclude the indictment in its entirety, that there was no reason to bring it. There was no link because I said it was prejudicial.
But once it's in, wouldn't you ask for that instruction?
Well, according to Ebron, there was no instruction, there was no request for it. It was that the judge did to do it to protect the client as far as the prejudicial nature of it. There was no request for it in that case. So even so, if the judge wanted to do that, it wasn't until the very end when she did it explaining the difference of what an indictment is. But that had nothing to do with my client.
Okay, but how did, I'm not sure that as the trial judge I would have admitted the indictment. So I may end up agreeing with you on that. But here's the problem, harmless error. Because the jury did find that Maurice caused the accident. So how is the admission of the indictment, which I do think is questionable, determinative here?
Because it goes to the heart of credibility of the plaintiff. If they're already having some type of doubt, and then they're hearing these type of allegations, it just goes ahead and...
His own conduct was enough on that.
But we will never know. The problem is that we go into such deep...
Okay, but if they really thought that he was that much of a liar, they would have ruled against him on the liability.
Well, if you look at the jury question would tend to wonder if that is what they were thinking, because they automatically...
I know, they asked about it, but they ended up ruling. They said, do we have to agree on all law? But they ended up ruling.
They had a video, though. It was hard to even say that the liability was at issue when they see the video, but it didn't mean that they didn't have in their head the mindset of hearing all this prejudicial information that had nothing to do with my client. There were several times, Your Honor, where my client's sitting next to me and he's saying to me, who is this man? What does he have to do with my case? He did not know him. And that is extremely prejudicial. And I'm here trying to explain to him that it's okay, but it's not okay. We have to set the standard to protect this. This is why there's 403. This is why there's 404B1 and 2. And it even says, it was hard to find a case that had to do with a civil matter regarding an indictment to come in. But there was Garcia versus Aetna casualty that clearly said, and that was even a closer nexus. That was a case of a fire and a relative pled nolo contendere, and they even said that that indictment was not going to come in on the basis of intent, motive, or absences of mistake or lack of accident. That is huge, because that's exactly what happened here.
Okay, what's your best case for the proposition that something that came in wrong on liability also means that you have to reverse on damages?
I'm sorry, Judge, if you can be just a little more specific as far as what, because I thought there was a lot of things that came in wrong. For example, the indictment, the deposition, the Fifth Amendment. So if you can clarify.
Because everything you're complaining about that came in wrong had to do with liability. So my question is, what is your best case for the proposition that the admission of something that has to do with liability that shouldn't have been admitted, and then the person wins liability, is not harmless error?
To do the first step, I don't think that everything that came in was about liability. I think that everything that came in had to do a mixture of liability and the character of the plaintiff. And that's where I go with the basis of this is not a precedent case that talks about highly factual issues, because we have not gotten the guidance as to what intention
So what
is.
specifically on liability went to the plaintiff's character
This-
that shouldn't have come in?
Well, again, like I said, Judge, I think it's the mixture of the indictment, the deposition of the Fifth Amendment, of the invoking the Fifth Amendment, the criminal attorney coming in talking about the stages of accidents. I mean, if you remember, the defendant's affirmative defense was just intentional, but then the district court judge all of a sudden started saying, when allowing the deposition in and saying your client was part of this larger scheme of staging car accidents. That was never an allegation. That's where it goes into the point of this went beyond as to what even the affirmative defense were from the defendants. That's a significant issue. That goes.
When you say the district judge started saying that, you mean she said that to the jury?
No, she's allowing the deposition of invoking the Fifth Amendment of the non-party. She allowed it in and stating that, and their defense is that, your client was part of this larger scheme of staging car accidents. But there was no allegation of the sort. It was just plaintiffs intentionally caused the accident. And so the point is that it goes into this theme of tainting my client, never having a fair shot, when even the allegations that weren't even in their firm defenses are now me having to have that fight.
One thing that influenced me here is the defendant didn't argue anything about the staged accident theory in interrogatory number 2. They made a brief reference to it in interrogatory 1, but most of their argument was on interrogatory 3. So there's, you know, the defendant didn't argue credibility of the plaintiff because of the staged accident theory in interrogatory number 2. So, I mean, you have to be arguing that the jury thought this up on its own. It got all the way down. It got through liability, which would have been the logical place for them to consider that. And they got down to number 2, where no argument was made that about the staged accident, and they thought of that themselves and said, well, we'll get him here.
Well, Judge Davis, I think that actually throughout the whole theme of defendant's case was staged. They started from the opening to the closing. If you look at reading the indictment, it was all about staging and fraud and similar
In closing argument, which was the last thing the jury heard, the defendant did not argue staged accident in interrogatory number 2.
In their if we're going specifically in the interrogatories, you are correct. It was just it was very limited on that. However, hearing what the jurors hear to put all the totality of the circumstance and the totality of the evidence, they kept hearing it days and days as to staging fraud, having a criminal defense attorney come in that had no bearing or link. You have to link, and there was no linking. That was the big issue.
Well, it was the phone number.
So about the phone number, and I'll finish with that. The phone number, first of all, there was no conversation. There was 2 different records, which is, I mean, extremely disheartening to see, but it is scary, that you have one AT&T record that has no record of the phone conversations at all, the same phone number. Then you have a Sprint one. Now, I tried to bring a T-Mobile expert to show that those phone calls never connected. So be clear that Mr. Garrison, the non-party, and Mr. Robert never, ever had a conversation, to be very clear. And when I tried to bring in that T-Mobile expert, because what happens is when you ask a phone company for someone to come into trial, they can't give you the name until you give them the dates, and then they find who's available. But it was very clear in my pretrial order who it was, that there was a T-Mobile person coming to testify in that. And I was unable to bring that. But even still, the defendants had a burden to show that link, and they didn't. They just made the allegation. It's their burden to show that there was that. And furthermore, with the defendants, and I'll finish with this, the defendants intentionally withheld evidence in this court, which is ill practice, which goes from case law to show that a judgment should be vacated when there are such ill practices such as this. My time is up.
You've saved time for rebuttal.
Yes, Your Honors, thank you.
All right, we'll now hear from Mr. Gaudet. Is that how you pronounce it?
Close enough. Gaudet.
Gaudet. Okay,
Yeah, thank
sorry.
you. That's all right. Good morning, Your Honors, and may it please the court. My name is Nathan Gaudet. I'm counsel for the defendants in the underlying lawsuit. There's a lot of issues that were appealed in this case. Obviously, I wanted to talk about some of the things that counsel talked about and that Your Honors talked about. Number one, all this, we did indeed believe that this accident was staged by Mr. Robert with the assistance of Mr. Garrison. And we certainly thought we had found a link where we found Mr. Robert's number, which in discovery he kind of beat around the bush about giving us. Then we got it, and we found his phone record showed Mr. Garrison's phone number was in there twice before the accident. We knew from other
Your opponent says they didn't actually talk.
They may have not actually talked, but is it a signal to, you know, pre-arranged thing? Did they text and that didn't show up? I don't know, but the point is, we had a link, and then Mr. Robert lied about it in his deposition when asked if you ever had any calls from this number. And that alone, I think, is enough to get into the jury's heads that, wait a minute, you know, there is this link between this guy staging all these accidents in the New Orleans area, just like this one in this accident, but we lost on that, as you pointed out, Judge. We lost on liability.
Okay, but your opponent claims that because you focused on that so much, it just kind of threw out everything on Robert, and therefore that's why he lost on the damages. So what do you say to that? To me, that doesn't make any sense. If they're gonna believe, just like you said, that he's such a bad guy, I don't understand why they would give him the accident and then not medical causation. We ran the risk of looking bad, in fact, by putting this affidavit out there
and maybe the jury thought we were being abusive of him. I don't know. The jury wasn't polled, but we know that they found liability against my client, Mr. Maurice. You know, it's not like Mr. Garrison was indicted for something that truly had nothing to do with the case. I mean, there was a link. There were credible allegations. Mr. Maurice said, "I never saw this car. I looked in my rear view as I was executing my lane change. I never saw him." So we felt it fit the mold. The jury disagreed, and so they moved on.
I just do not understand under what theory you can enter in, and even assuming arguendo he was best friends with Garrison, how does an indictment prove anything? Somebody is innocent until proven guilty. You can't admit an indictment against somebody to prove anything.
The admission of the indictment at the trial level didn't prove anything at the trial level because we lost on liability. It fits.
Okay, but it is improper. I don't understand how it is proper. Please explain that, because I don't get that.
And I concede, Judge, I haven't found any guidance on that in really any federal court, at least based on some Westlaw research.
Is that to say you haven't found anything that says it is proper?
Well,
But
one way or
you
the other.
haven't found anything that says it isn't?
Correct.
Is that what you said? Okay.
Yes. We assert that it fits squarely in 404B2 as an act that is admissible for another purpose, in this case to show lack of accident. We feel that the district court was proper in allowing it, but even if the district court wasn't, what's a remand on that issue going to do? They already found against us on liability, and I don't see how there's no evidence in the record of it linking to his statements on medical causation. We didn't say Mr. Garrison was a criminal and birds of a feather flock together. We didn't say he was a bad man. We say he allegedly staged accidents just like this one in this area. And, you know, jury can make your own decision on the circumstantial evidence, and we lost.
Look, you tried to taint this guy all the way through. That seems pretty clear to me.
Well, sure. I mean, we thought he staged the accident. I mean, of course, we tried to tank him.
Yeah, but that's all you had was what you thought.
Well, we had the testimony of our driver saying that he didn't see anything as he was getting over, and we know from experience a lot of these accidents happen when there's somebody's in the other lane or behind the truck and speeds up. I know y'all heard of Judge Graves and Judge Haynes heard a similar case yesterday. That's exactly what we thought happened, but again, we were wrong apparently. I wish it would have been different, but I don't know if it made us look bad or not, but we were wrong. And so that brings to the next jury interrogatory, which was in fact medical causation. Mr. Roberts' counsel says that the defendants didn't dispute it. We don't have to bring an IME expert or anything like that. The jury was properly instructed that you can believe the plaintiff's doctor or not, or you can believe the plaintiff or not. They clearly didn't believe him, and you're exactly correct. Dr. Loneseth got on the stand and said, I don't remember him saying anything about other accidents. You know, yeah, okay, it's in the record, but I don't remember him saying anything, and I believe the chiropractor said the same thing. There were, in fact, 2 other accidents, both of which were sideswipes, by the way, in the New Orleans area. So all the more evidence we felt we had to show this accident was not legitimate. I'm sorry.
He'd had 2 other accidents for which he brought claims before this accident.
That's correct. In 2013 and 2014, both were sideswipes. One involved a commercial vehicle. So that all kind of played into our argument that this was, in fact, something that he caused himself. As far as medical causation, the appeal actually focuses on the denial of the motion for a partial summary judgment, as opposed to the jury's verdict itself on medical causation. That motion denial is not appealable to this court, so I think that issue is basically settled. We discussed a little bit about.
I will say I totally don't understand why you offered that, or you all offered that deposition of Garrison, because I understand that people can claim the Fifth Amendment who are not guilty, but a lot of people think, you know, if you're asking me a bunch of questions and I answer all of them except there's this one I claim the Fifth, people would tend to think that means guilt. But this guy, it wasn't even him claiming the Fifth on most of the questions. It was his lawyer, and he actually tried to answer one, and the lawyer jumped in and goes, "We take the Fifth." And so when the lawyer's just sitting around screaming, we take the fifth, how does that even say anything about Garrison and whether he's a liar or a criminal or anything? When you're just sitting there and your lawyer just keeps saying, take the fifth, I don't know how that says squat about anything. So why did you guys put that on?
Right. And procedurally, not having done any criminal law, I don't know how that works when someone's advised to plead the fifth. I didn't know if that's kind of what the lawyers do. The Fifth Amendment, the deposition wherein Mr. Garrison invoked the Fifth Amendment, again, it was presented to show he was specifically asked about this accident in his call to Mr. Robert, and he could have easily just said, no, I never heard of that guy.
No, he couldn't, because his lawyer, Kelly, kept saying, we take the fifth, not Garrison. It wasn't like Garrison was flopping through the deposition, answering some, taking the fifth on others, and whatever. His lawyer just kept, I don't know if he was screaming, or she, I don't remember if it was a he or she, the lawyer, but the lawyer just kept screaming, take the fifth, different versions of that phrase. That, to me, doesn't prove squat about anything, except that you have a lawyer who takes the fifth.
We had agreed, I think, during the...
And I guess for me, what I'm thinking is this. Garrison's dead by the time of the trial. And so if I got a jury sitting in the box, and my contention is that he staged accidents with a guy named Garrison, the jury's saying, well, why don't you call Garrison, let's talk to Garrison about it, except Garrison's dead. So if Garrison's dead, then maybe I try to use Garrison's deposition, because I can't call Garrison, but I got a jury wondering, you're trying to connect him to Garrison, let's just call Garrison as a witness, one side or the other, either to prove or disprove that there's some connection between him and a guy who's been indicted for staging accidents, and that's exactly what we're claiming happened in this case. So maybe that's why you call Garrison. I can understand you can't control what he says, and maybe because you have a deposition, you already know he's going to take the fifth because you're reading the deposition, but I can still understand why you may want to use the deposition. You got a dead guy.
That's exactly right. All we had was the deposition as far as Mr. Garrison goes.
I know, but it doesn't prove anything because, as I said, the lawyer's claiming the fifth. You could have simply told the jury that he died, and that would have answered why he's not testifying.
Yeah, I did not appreciate that the lawyer claiming the fifth is different than his client claiming the
It's
fifth.
not the different in terms of the outcome, that there's not an answer, but to me, in terms of determining, like, this guy is not wanting to answer, when the lawyer's the one taking the fifth, how can you even say what this guy would have done on his own?
Well,
It's a little hard. It just seemed weird. I'm not saying it's good or bad. I think I did. Well, maybe I am saying that. It just seems funny to me that it came in because I don't see the value of it to you all.
right, and again,
I'm right. You didn't win on that.
Look, hindsight's 20/20. I mean, looking back, I take your point. I mean, maybe that is an issue, and I take Judge Gray's point as well, because that is all we had of the gentleman. But in going back to the liability argument, this is an abuse of discretion call. I mean, it's harmless error. I don't know what substantial right is affected. Again, if there's a remand saying that Fifth Amendment deposition to come in.
So let's talk about the damages. Let's assume arguendo, harmless error, and talk about just the damages in general. You all didn't offer any expert testimony that contradicts his claim of damages, right?
Correct.
And so what about Ms. Motta's argument that, we put on evidence that this was different from his other accidents and he really was injured. And of course, if they find liability and he was injured from this accident, they do need to award some damages for that.
I think the jury instruction was proper, that with regards to the expert, the jury does not have to take it as gospel. With regards to the plaintiff, they're entitled to believe if he's lying about something, he's lying about some other stuff. And we also had, I apologize, this is not fleshed out very much in the briefer at all. We also had his employment records where it's showing he was working 60 to 80 hours a week at a pretty hard labor job after the accident. There was ample evidence. The police report, he didn't complain of injury. The officer body cam, he was walking around just fine. we didn't feel like we needed to parade some doctor out there to say what we were going to say based on the records themselves and what Mr. Robert himself has said. I think, Your Honors, with regard to the audio statement, it is simply not true that the defense did not give this statement to opposing counsel. It was received via subpoena to Progressive. We got it on February 14th. I remember at around 3 o'clock. It was fairly voluminous. I went through it, and on the very next day, February 15th, 2022, we sent it via Dropbox and on a disk or a flash drive to counsel. The fact that the claim that they didn't have it is not true. And then on the stand, Mr. Robert authenticated it, said, yeah, that's me. That was after this accident. That was my statement to Progressive. So, I mean, the idea there's some kind of nefarious thing going on there. It's true that we did not request an in-camera inspection. It was not on the scheduling order. The way I read the scheduling order, and Judge Brown very much corrected me that I was wrong, and I'll never do it again, but it said we may request an in-camera inspection for pure impeachment evidence. I take that to mean, and I quoted the Texas v. United States as 40 F4th 205. I took that to mean that we could basically risk it, and we did, and that's why I went in the scheduling order. Not going to do that again. Certainly learned my lesson, but that is the explanation for that particular evidence. The next thing we haven't really talked about, I just wanted to touch on, is again the motion for partial summary judgment on the affirmative defense. The plaintiff, Mr. Robert, claims that that was sufficiently preserved by a Rule 50 motion for judgment as a matter of law. If you look at the record, it was not sufficiently preserved. I think sufficiently is important there. Furthermore, insofar as judgment on a matter of law was made as to liability, it was to liability only. It wasn't saying, Judge, you messed up on this summary judgment motion. You know, we're entitled to summary judgment. It said we're entitled to judgment on the liability argument. So again, we feel that denial of that summary judgment is also not before the court from a jurisdictional perspective. And finally, Mr. Robert argues that the court erred in denying the Rule 50 judgment, motion for judgment as a matter of law on medical causation. We've talked about this. I mean, there's ample evidence that this guy was not injured in this accident and lied about his past accidents to his doctors, his past injuries, all of which just happened to be sideswipe incidents as well. And just to address a couple things that counsel brought up. Number one, she said there was no instruction whatsoever about the use of the indictment. Again, not true. Record 3520, in real time, the judge instructed the jury that these are just allegations. There's not evidence that he did anything wrong. These are just allegations. And more importantly, in the record at 3774 and 3775 was when the judge instructed the jury after closing arguments, and there was no objection to this instruction at the charge conference. In fact, counsel for Mr. Roberts specifically said, yes, we approve of that instruction. So the statement that Judge Brown did not instruct the jury is not true. She did multiple times. If you have any other questions for me, Judge, I think we've covered a lot of ground. I'm certainly happy to answer anything else.
All right, thank you.
Thank you all.
You have your argument. And Ms. Motta left time for rebuttal.
Yes, Your Honors, thank you. I'm just going to go real quick to that last statement. What I said was that the judge did not give it contemporaneously. So she did it at the end after everything. So that was just wanted to make that very clear. Regarding your question about the deposition of Garrison, again, we have to have a link, and there was no link. I know that there's no clear case here. I'd like to apply the Labuti case, which was the FDIC is where you look for a case-by-case and why you would bring in a Fifth Amendment indictment, or a Fifth Amendment, deposition. And in the Labuti factors, it has 4 great reasons as to why. First one is the nature of the relevant relationship. They did not provide any type of nature of the relationship. Even, defendants even said that, well, the call may not have connected. Well, it did not connect. That's the whole point. But furthermore, you go into the degree of the control over the party and the non-party, the witness. There was none. They used an employee-employer situation type of more of a connection of a nexus, and there was none here. Then you talk about the role of the non-party witness in the litigation. And Garrison played no role here. There was no connection. This whole thing about, oh, it's a sideswipe, another sideswipe. There's really only two ways to have a collision on the interstate. It's a rear ender and it's a lane change. You've got a 50-50 shot to be safe. Okay, and that's exactly, this wasn't just some sideswipe. This is on the 90B on O'Keefe, where the truck driver is going up the ramp and he crossed over in a white solid line too early, just too early, and hit my client. This isn't what's going on as far as, oh, it's a sideswipe. It's very different just to say sideswipe versus a lane merging or a lane change. Extremely different here. And to lose that sight and then say that he had priors, those priors were accepted, they were there. There was no sense of any type of intentional stage or fraud to try to taint, again, my client. But going factor on this, on your question, is there was no nexus for Garrison in any way, shape, or form. In regards to the medical causation, they had argued in the MSJ solely based on argument. And that is not what satisfies MSJ. MSJ, you must have competence evidence, and that's not what they provided. The same thing with the affirmative defenses. And even here, hearing defendants, they said that we believe that it was staged. That wasn't in their affirmative defenses. That goes beyond the issue here, is that you go back door of this 9B heightened pleading of staging, which is synonymous to fraud, and you don't set the tone in the affirmative defenses, and that's where the trial by ambush is. And I'll last finish about the recorded statements of progressive if it wasn't intentional. I can tell you with Judge Brown's orders, it is very clear to do a in-camera inspection. I did it in this case for it, and it's very clear you have to do it. And I see that my time is up. If I may finish my response regarding the progressive. Thank you. The point is that she knew that it was intentional. Even Mr. Perrier said that we just were fearing that it was going to get struck. Right there of having those ill practices, someone who has been practicing for a very long time to make that comment, is reasons why that should have not been struck, not only been struck, but it should have been a jury instruction to disregard that. And I thank you for your time.
All right. Thank you, counsel. We have your argument. The case is now under submission, and the panel adjourns. Thank you.